My boyfriend and I were playing last night, and I put him in a case and we were playing. I'm the blue-eyed white dragon, that's what they call me.
For the purposes of trial, you will be hands-free and you will not be shackled with legs.
Okay, so I would be unbound. I know this is a lame question, but what does sustain mean?
Sarah Boone could have the help she wanted when she appears today in court with her new attorney. But the suitcase murder trial could be delayed yet again if Boone and her counsel get their way.
Hey everybody, Derek Judd here with Cowboy Criminology. Of course, I am your host, the Cowboy Criminologist. So I want to thank y'all for kind of bearing with me. I'm 5 weeks into law school, started my 5th week, and between family commitments and, as you can imagine, a whole lot of studying, there's just been a lot going on, and I kind of explained that in the last video. I was trying to kind of get on more of a schedule as far as my videos and stuff go, and I'm still trying to work that out. Time management is key. So there have been some comments on Cowboy Criminology that you never see me wearing a hat. And like I said in the last video, I never really thought about it because as a general rule, I don't wear a hat indoors. And but anyway, in case you were curious, yes, I do own cowboy hats. This one is one of my favorites. It's kind of a Texas tradition. This is the Master Hatter Texas Ranger, and I had one just like it that blew away from me on a traffic stop, and I was so glad when I found this one. But it's just a classic hat, just a nice sturdy straw hat, keeps a good shape, fantastically made. But it's Master Hatter of Texas, and I'm not sponsored or endorsed by any, or I don't really do promotions on this channel, or at least at this very early stage. But I just always like Master Hatters. I think they're a great quality, they're a great price, and I just like the look of them. Rules for wearing a cowboy hat: when the weather starts to turn, the general rule is after Labor Day you switch from a straw hat to a felt hat. But when it's still 90 plus degrees outside, I don't think anybody would give you too much of a hassle about wearing either one. But I do tend to like there to be a little bit of a chill in the air before I switch over to my good silver belly, because the last thing I want to do is sweat through the felt on that, because it's really nice. So little housekeeping things. So y'all, I've had a lot of requests, and I apologize. I've lost track of what has been asked of me. So if you would do me a favor, if you send me an email to Cowboy Criminology or to Cowboy Criminologist at yahoo.com and just ask for a special request video, I can start putting those in some kind of order where I could start getting to those. And moving on from there, y'all, I thought I was going to be done with Sarah Boone at least until October. But what have I always said about Sarah Boone? She is the true crime gift that keeps on giving. And nowhere is that more evident than somebody actually, an attorney, a very qualified attorney, I might add, answered that cheesy little ad that she did. But that wasn't without some issues. That wasn't without some reservations on the part of the attorney. But now it looks like she's put together a legal team. She's got her primary attorney, and it looks like she has a second. Now, when she was talking about doing that, in the last video we did about Sarah, we were talking about how Sarah representing herself sets the stage for appeal. She's been big about talking about discovery, and I know a lot of you have said, you know, she knows what's in the box. She knows what's there, she knows what's not, and I'm inclined to agree. A new attorney coming into a case has an effect. And while, yes, we understand that everybody wants to see this trial get underway. All right. The judge probably leading the charge on that. The judge probably wants this trial over with more than absolutely just about everybody except for George's family. But like I've told y'all in the past, we got to make sure that due process is actuated, and that we're doing everything by the book. When I was a supervisor, my officers caught a DUI of a very high-profile individual in the community. And I kept having the officers go back through and redo their reports because things that didn't match, timelines didn't match, who did what didn't match according to what was on the body camera. And I had an officer tell me, the report doesn't matter, they're going to see the body camera. Okay, sure. What happens if the body camera video gets thrown out? What if the audio from the body camera gets thrown out? What if the audio gets to stay, but the video gets thrown out? It's very, very hard to challenge body camera video that matches perfectly with a well-written report. So the next excuse, the fourth or fifth time I had the officers rewrite their reports, was that he's just going to get away with it. He always does. Well, those officers handed this individual his very first DWI conviction. And judging from his past behavior, it's not going to be his last. He has a very slow learning curve. But that's the thing. You've got to do... Yeah, I get it. I get it. You want to take shortcuts. You want to save time. I get it. But do you want to hold people accountable for the crimes that they're committing? You know, do you want somebody who habitually drives while they're intoxicated out on the same roads where your family drives, rides their bicycles, walks to school, walks to church? I know I don't. So it's worth it to do it right. All right. Now, on the other side of that, I tend to be very centrist on this channel, and I tend to call out what I think is the good and the bad based on my opinion, training experience, and education. Sloppy police work doesn't get a free pass just because it's police work. Bad police work is bad police work. At the same time, good police work needs to be recognized and acknowledged for what it is. And not too long ago, I did a video about Justin Timberlake getting stopped for a DWI, and everybody was like, "Oh, this case is going to get kicked." A lot of the talking heads were like, "This'll never see a courtroom." I was like, "Oh, you're right," because he's going to plea. That was always my contention. But if you remember, I looked at the officer's report and I was like, "This seems like a solid report. I don't know what he's planning on fighting." Well, just a couple days ago, he ended up pleading to driving while intoxicated. So, just one of those things. Good police work needs to be rewarded. But by doing good police work, you're able to hold people accountable. All right? So, we're kind of learning a little bit more about Sarah Boone and her new attorney. Now, her new attorney has over 35 years of criminal defense practice. And this is a wonderful, wonderful, wonderful thing for Sarah Boone's case. We've pretty much already established that a plea bargain, while not completely outside of the realm of possibility, there are certainly things that are a lot more likely to happen. But the good thing about this is now the judge doesn't have to worry about safeguarding Sarah's rights as a defendant. He can just run the trial, which is great for him because he shouldn't have to do double duty. The other nice thing about this is a competent defense can certainly lower the risk of having something come up in appeal, or having something come up in appeal that wrecks the prosecution's case. Now, with this great news that, you know, Sarah Boone's kind of putting together new representation, there's also a concern that I have. Okay, it's the same concern most of you have when, you know, she was on lawyer 5, 6, 7, 8, and here we are with 9 and 10. My concern is that Sarah is going to tell them something they don't want to hear or can't be done, and she's going to start this process all over again. Now, the nice thing is, yes, there are some fundamental facts of law that are going to come into place, but eventually this trial is going to have to get underway. And Sarah is not going to be able to keep hiring and firing her attorneys at will without any repercussions. So let's take a look at kind of where we're at with this. Where we're at with this whole thing, and I want you to kind of get a deeper understanding. And then I'm going to kind of throw in my 2 cents. So let's check this out and see what we've got.
That is, of course, our top story for you this morning. So many of you interested in the suitcase murder trial, right? And we've seen delay after delay after delay. And, well, guess what? This morning we're seeing that Sarah Boone may have a little help in the courtroom from an attorney from Pensacola, Florida, who is stepping up to represent her. Now, if you remember, she's gone through 8 lawyers previously and was essentially made to represent herself.
For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
So Sarah Boone then created an advertisement. Remember this? She advertised for an attorney to help her, and it appears it worked. Because on Friday, attorney James Owens filed his notice of appearance and then immediately filed a motion asking for a continuance. In the motion, he noted that he was drawn to the case after, get this, seeing her advertisement from watching court TV. How about that? Now, in an interview with us, Owens says, quote, "She hired me. She retained me. It's a little different because it wasn't someone who was handed to her. She picked me. I plan on seeing it through, and I'm determined to help her see it through." End quote. All right, we'll see what happens this morning. Let's talk about this. I've got 2 great guests standing by. The Director of Prosecution Projects at Florida International University. She's a former homicide prosecutor. Melba Pearson is with us. And want to welcome back in forensic psychologist, expert witness, Dr. Michael Brannon. Great to see you both. Oh boy. Okay, so the likelihood, let's just assume that everything works smoothly. He shows up at court this morning. The judge notes that he is now counsel of record. Will he be given a continuance? Melba, what do you think?
Yeah, good morning, Julie and Doctor. I think that he's going to get that continuance. It would be an appealable issue, I think, if he doesn't, because he's brand new, just stepping into the case. He has to have the opportunity to read the file, prepare. If he was just retained on Friday or basically in the last couple of days, there's no way he can get up to speed to effectively try this case. So I think a short continuance will be given to him. Now, I don't think it'll be 3 months or something like that, but I could see a scenario of a couple of weeks to a month in terms of a reset date in order for this trial to finally move forward.
Sure. Appreciate it, Melba. I have a little bit of the motion for continuance we extracted just to see a little bit of what he says. And get this, he talks about meeting with Sarah Boone 4 times at the Orange County Jail already. And he says during the meetings, they discussed exculpatory evidence on her phone, which they hope will potentially corroborate her battered spouse syndrome defense. Dr. Michael Brannon, this is where I want to bring you in. We all saw you testify in Marsha Thompson's case, and you were really the star of that trial, the breakout star of that trial. Your expertise really shined. Looking at this case, and I know you haven't personally evaluated Sarah Boone, but based on what you know and the facts we see them, do you think she could be successful on a battered spouse syndrome defense?
Well, good morning, Julie, and Melba, too. Good morning. So it's a very difficult defense, even when everything is all put together nicely for the defense to occur. And there has to be a number of different elements that fit in order for the battered spouse defense to be successful. And in this particular case, you know, there's a reason why people go through a lot of different attorneys. Some of them may just be stall tactics. Some may be trying to establish a certain defense. But attorneys may be, and again, I didn't talk with her, I don't know that much about the case, but attorneys may have already told her, listen, you don't meet the elements of this, or this is not going to be successful, trying to give her the benefit of their legal knowledge and background, and she may not have been willing to accept that. She may have heard from other inmates or family members, or she may have seen it on TV and thinks it may be a good idea, but the facts of that, the elements may not apply directly to her case.
Appreciate that, Dr. Brannon. We know in one of the motions that her new attorney filed, he said that he's looking for additional discovery. And of course, that caught our attention because we're thinking, what else is there? We've been talking about this case for years. Melba, as you know, you've given us analysis for years on this one. What else could possibly be there? It seems like Sarah Boone is hung up on discovery, quote unquote. We've seen her, you know, there before the judge saying, you know, I'm not being given everything. I'm not being given everything. And, you know, looking as a spectator, you know, someone who's on the outside. I'm not part of the case. I'm not the prosecutor. I'm not her defense attorney. You know, I'm just scratching my head because we know there were 2 people at that house that night, the 2 of them, when this happened, and she created the most incriminating evidence by filming him and not letting him out of the suitcase. Melba, do you think this motion could have teeth? Do you think this is a formality? I'm curious your legal opinion on why this attorney would say he thinks there's still something outstanding that hasn't been turned over by the state.
So, of course, as in any prosecution, you have the duty to turn over any evidence that you're going to be relying on in trial, or just generally, and my always rule of thumb was always, when in doubt, send it out, right? So that way there's never an issue later on down the line. You didn't turn this over. This could have been exculpatory. You mentioned this in trial. I didn't have access to it before, et cetera, et cetera. So sometimes in homicide cases, when you have a lot of different witnesses, you have many different people that authored reports. You may not, there could be a situation maybe where 1 or 2 reports didn't get turned over. It happens. It's, often accidental, not anything untoward, but it happens. So it's possible that the defense attorney, in the abundance of caution, is just renewing his request for any and all discovery that might be pending, just prompting the prosecutor to go through the file again and just ensure there wasn't anything turned over. Now, of course, it could be a stall tactic on the side of the defendant, because again, yes, to your point, Julia, she knows what discovery she created, but also is a tactic to know, is there anything else out there that can be used against me? And how do I deal with that? How do I handle that in advance of the trial?
Excellent insight from you as always.
So yeah, that's some really good balance right there between the attorney and the doctor. Yeah, the battered spouse defense is very powerful. Less so when you have the type of evidence that we saw in previous videos, where George is trying to get out. He's saying he can't get out, saying he can't breathe, and Sarah's laughing, and she just there's nothing there, no concern, no concern for him in the slightest, and that creates a very difficult hurdle to overcome when it comes to trial, because now opinions about Sarah Boone have already been formed. Regardless of what anybody knows about the trial, she's on her 9th and 10th attorneys. That right there makes people think that she's very difficult to deal with. Her affect in court is very difficult to overcome. Her demeanor in interview and in the original body camera is very difficult to overcome. She just has this, what was the word we came up with for her? Insufferable. That seemed to be like the perfect way to describe her. And here's the thing you have to be careful about. As far as a defense attorney, the prosecution already has dumped that phone, and they have everything that's on that phone. So they want to be very careful about what they introduce as far as that battered spouse defense, especially in the light of how George died. And there's a history of domestic violence back and forth on both sides. George to Sarah, Sarah to George. It's been an ongoing cycle between the two of them, as it is in most domestic violence relationships. So they want to be very careful, because conceivably the defense could get something from Sarah's phone entered into evidence that may help her case, but the prosecution may sit there and say, okay, well, if you want to show that video, oh, look, this comes straight from her phone. This is what we're going to show. So like I've told y'all before, I'm 5 weeks into my first year of law school, so I'm certainly not qualified to make an opinion about that, but it just seems like something that it seems like a card I'd want to be very careful about playing. All right. I feel like it's something that could just kind of jump up and bite me if I wasn't ready for it. But so she's got an investigator now. She's got an attorney, and that's good. And that's good. We kind of have an understanding of how all these things kind of tie together, where we're trying to figure out or get a better sense of kind of what the procedure going forward is going to look like. Is there going to be a continuance? Yeah, there almost has to be, because that would almost certainly be an appealable issue. And, no trial court is going to want their decision overturned, especially in a case that's garnered this much attention. So I really kind of see things. I think the judge kind of has a Solomon-like decision to make. He's got to balance getting this trial moving with what's going to be fair. And I think the prosecutor, Melba, kind of nailed it. She, 3 weeks, maybe a month, but we're not looking at 3 months down the road. She doesn't think the can's going to get kicked nearly that far, and I would tend to agree that would not be in the best interest of justice or or beneficial to either side. Now, somebody did ask me when they found out that I've been covering the Sarah Boone case, they said, well, what about her right to due process and her right to a speedy trial? Due process is being upheld, as we can clearly see. I feel like the judge has been considerably more patient, understanding, and tolerant than I think a lot of judges would. Now, as far as her right to a speedy trial, there's really only one person to blame for that. That's usually aimed towards a prosecutorial or law enforcement, holding things up, delaying discovery, delaying motions, things like that. Those usually come from the law enforcement and prosecutor sides. The delays we've seen in Sarah Boone's case, Sarah Boone is the lowest common denominator in that. All right, so that's not really an issue. And sometimes, sometimes there are just things you don't necessarily tend to think about. And that's kind of the cool thing about this channel is, there's hundreds of other YouTubers out there following the same case, and there's a lot of attorneys doing it, and they probably have more material insight into what I did, into what how the Sarah Boone trial looks to them. And I'm just kind of going off of the perspective of what would a law enforcement officer have to do to get this thing, to make sure they weren't the reason things were being held up. And like I've said in past videos, I've just been really impressed with the sheriff's department who had handled this case. I know some people disagree, and I know some channels disagree, but hey, that's the wonderful thing about America, is everybody's entitled to their own opinion. So let's go a little further, because I think we got a little bit more from the doctor, and I like his testimony. He's obviously very knowledgeable about what he's about his point of view and how he sees things. And he's not really committed to one thing or another. He's just very matter of fact about, under these circumstances. And so let's hear a little bit more from the doctor and see kind of what we got.
Oh, but thank you. Dr. Brandon, let me go back to you, please, on the issue of battered spouse syndrome. Sarah Boone, we know, is a very strong-willed, shall we say, woman who seems to know what she wants. She had difficulty getting along with the 8 prior attorneys. Maybe 9 will be lucky number 9, who knows. But tell me, if she is intent on going forward with this defense, or at least exploring it, what does that look like from your perspective in consulting? Would you kind of take us behind the scenes? How would that go?
Sure. So you'd want to know right away whether there's any control tactics that were being done by the victim in this case. Was there a pattern of abuse? Was it ongoing? And was the individual, the victim in this case, so controlling that she wasn't allowed to contact, be in touch with other individuals, be in touch with family members to try to get help? And did she make other attempts to try to get away from the abuse? And I'd also note that the method of death here that was utilized by Ms. Boone on the victim, it would be unusual for a battered spouse case. Usually the actions are impulsive, they're quick, a quick gunshot or a quick stab wound. But this type of killing is really unusual and almost unheard of for battered spouse cases. So they'd have to overcome that as well, because it appears that there's some thought, some intent, but also some lingering time for her to think about what she's done. And oftentimes those are not synonymous with battered spouse defenses.
I appreciate it, Dr. Brandon.
There's a lot of thought and a lot of intent that went into that. And I've said this before, intent can form in an instant. Intent does not have to be this long, drawn-out, premeditated, I'm going to get somebody out of bed at 7 o'clock in the morning, and I'm going to make sure that 8:30 p.m., they're standing under the church where I push a gargoyle off the top of the church, and it hits them. It doesn't have to be anything. It doesn't have to be anything that creative. Intent can be formed in the moment. What kind of gets me here, though, is like the doctor said, and I couldn't have put it better, is in battered spouse cases, the violence is usually very sporadic, instantaneous, and usually the batterer doesn't see it coming. It's usually something, you usually find out about batterers that are killed in their sleep, or otherwise engaged in other activities, fixing the sink, working on a car, something like that. And this one, yeah, it's very unusual, because this is usually something you see in body dumps, and this is usually something you see, unfortunately, in extreme child abuse, child neglect situations. So it's very sad, but I certainly appreciate the doctor's expertise in this area. He's not an apologist, that's for sure, but he's very matter of fact about what his beliefs and his findings are. And I think for me, that's what helps make him so credible for me. And credibility in an expert witness, you know, every witness you put on the stand should be credible, or you should be able to explain their past and why you might not be able to find them credible, and get ahead of that. Because juries don't like to be surprised. I learned that in the academy. Juries don't like to be surprised. So if there's something a jury needs to know, prosecutor needs to tell them, hey, there are some issues you're going to find out you're not going to like about this person's history, this person's past, what have you. And so, but I think he does a great job, and I think he'd be a very, very difficult expert witness to find fault in. Okay, so let's go a little further. Let's see what else we got on this.
Dr. Brandon, tell us, what are you looking for as this progresses? What are you listening for, watching for with Sarah Boone's trial?
So does the evidence show a pattern of abuse, and does the evidence show that she's tried other methods to try to escape from that abuse? And remember, these are difficult defenses. And the reason why they're difficult is you're asking jurors to not believe what they see, but to really believe what they can't see, which is what a person's thinking and feeling. And the attorneys in this case, with their evidence, have to be able to show what she was thinking and what she told other people, and not just what she did, but what she didn't do. All those things are very, very important in establishing a battered spouse syndrome case. In this particular case, if she hasn't shown those elements, it'll be difficult to get that forward with a jury.
Appreciate.
Yeah, those are all really good points. And remember, if we're looking for justice for the victim, for George in this case, we need to make sure that due process is followed, because the last thing we want is an appeal coming through on Sarah's behalf if she's found guilty, and then creating a situation where nobody's ever held accountable. And there's case after case after case after case where that's happened, where people have been so quick to point a finger, and then a case falls apart, and everybody's sitting there going, wait, what happened? Well, how do we fix it? And everybody's like, I don't know. That's not a good place to be. So, due process. We want to see that. We want to see that due process. Yeah, those are good points. When he talks about, so the legal definition of that is the subjective standard, and it often goes to what people are thinking. Excuse me. And what you have to understand is battered spouse victimology is very specific to one group of people. And so the doctor is absolutely 100% right. You have to get the jury to understand why certain actions weren't taken, why certain actions were taken. One of the common things is, well, why didn't the individual just leave? Why didn't the individual do this? If things were that bad, why this, why that? So, very, the doctor hit the nail on the head.
A continuance, and if so, for how long?
The jury to understand what they can't see, and that was just a brilliant way of putting that. Yeah, very, very impressed. I like court TV. Their commentators from the legal side, from the forensic side, and the law enforcement side. They all do such a good job. I'm always really impressed, and I'm always a little. I always wish there was like a bio that I could find on their guest, just so I could do a little more research into them. But let's take a look one more time at Sarah's little. It reads like the worst human resources recruiting ad ever conceived, because it's just got every generic human resources buzzword in it. But let's take a look at that one more time.
And then Sarah Boone filed this want ad looking for a lawyer. Would anyone answer that ad? Would anyone step forward to save Sarah from representing herself?
I disagree with that. Sarah didn't need to be saved from representing herself. Sarah needs to be saved from herself. She has done herself zero favors since this whole thing started. It looks like the plea agreement is off the table, and I think we talked about that. I think we talked about that in the last video we did about her. So it's just really difficult to see where any of this is going to go. All right. So let's kick this off.
Tonight, we speak live with the man who answered the call, the man who will, believe it or not, represent Sarah Boone.
He's got an uphill battle. There is no doubt about that. There's no doubt about that. But you know what? There's a lot of speculation going around about why he did it and everything. But Court TV actually got him on the phone, and his reasoning is really interesting. So I'm just gonna let this play, and I want y'all to kind of hear, and I'm gonna kind of walk you through kind of where this takes my mind. And there's something, not that the lawyer says, but what he doesn't say, that kind of gives me an aha moment. And I want you to start thinking about it. Listen to what he says, and then listen to what he doesn't say, and see if we're on the same page.
Inmate seeks attorney. Looking for a prosperous challenge? Ready for your close-up on national television? Are you zealous with a side of keen? Show the world who you are with your original creativity, extraordinary expertise, confident ingenuity. Qualifications must include being trustworthy, honest, passion-driven, open-minded, exceptional problem-solving skills, client inclusion at all times, team orientation, collaboration, extreme efficiency in listening, communicating, understanding, dedication to success, possessing a winning mindset, capability of excellence in representation, committed, maintaining faith in the client and case with the ability to think differently, overcome all circumstances. Epic opportunity awaits. Sarah Boone, number 20005623, Orange County Corrections Department. Invest in the oppressed. Believe.
So who would believe in Sarah Boone? Well, someone did step forward to take this case. Yes, an attorney in Florida. Joining me by phone, Sarah Boone's 9th attorney, James Owens. James, thanks so much for joining us tonight.
Thanks, Vinny, for having me.
Okay, the first question I know everyone's asking you, why? Why did you take this case, James?
Well, you know, I watch a lot of YouTube.
Y'all wonder if he watches the Cowboy Criminologist? I don't know. You think? Wonder if it would have changed his mind if he had seen my channel and watched my take on her. If he'd have been like, you know what? I'm still going to take the case. I don't know. Moving right along.
And I watch a lot of court TV, and I've been following this case just like all the other true crime people do, and you know, kept watching it being delayed and the lawyers being switched, and then saw that the judge got fed up and ruled that she had forfeited her right to a court-appointed counsel. And so that's a rare event. You know, as lawyers, we know that, you know, everybody has a right to a lawyer, a court-appointed lawyer, if you can't afford one. So on a serious charge, a felony, in this case it was a murder, for the judge to revoke that right was a serious decision on his part. I don't disagree. I respect the court's decision, but that left her facing a murder charge without a lawyer, which is unheard of, I think. And so, you know, I watched for a while, and then I saw the ad on your show, and I think that you had said something implying, hey, who's gonna take the case? What lawyer in Florida is gonna pick up the torch, so to speak? And I think you had somebody on, maybe it was a lawyer from the Northeast, and I think I remember that lawyer saying, man, if I was a license in Florida, I'd take the case, you know, under that scenario, because she really needs a lawyer. Everybody needs a lawyer. And so the ad came out, and I sat there and waited for 3 or 4 weeks. I can't remember now how long I waited, but I was thinking that a lawyer out of Orlando would pick up the case. Somebody would think, hey, this is not right. There's no way she's going to get a fair trial representing herself. It's unfair. But there's a gap in the system. The judge made a decision based on her conduct that she had forfeited a right to a lawyer. I believe that's where the private sector has got to step in. Somebody in the private sector in that situation, and it's rare, should step in. So I waited. Nobody responded in the local area. So I just happened to have a case down in Hillsborough County that I was going to, down in Tampa. And so I knew I was scheduled for court down there. So about a week before that, I sent her a letter, and she had a third party contact me to, I guess, check me out to see if I was legitimate. And
well, I think everyone's been checking you out in the last couple of days, and everybody knows you are absolutely legitimate.
So it's hard to argue with. It's hard to argue with his reason for wanting to get involved. You know, I can kind of see, yeah, let's wait and see if somebody else, you know, picks up the slack and takes it on. But I mean, in Orange County, she probably just has a horrible reputation, and that makes it really difficult to want to force anybody into representing her. You know, I bet there were law firms in Orlando that were getting their pro bono hours knocked out really quick. It's like, oh, sorry, we've met our quota for the year on pro bono, Judge. If you just catch us next year, you know. But yeah, some interesting things there, and kind of interesting how he got into that. And the whole thing about the private sector needing to step up. I mean, you know, sometimes you gotta put aside your bottom line to help other people out. But that raises a very interesting question, and I think we're going to get to that here in this next clip. So let's check this out.
James, I mean, you have quite a history.
I've been doing it a long time. So anyway, she reached out to me, and then a couple of days later, Sarah called me from the jail in Orange County in Orlando, and we talked for a little bit, and I explained to her that I was coming down that Wednesday, but I'd come down early and spend Tuesday talking to her, and she agreed. So I drove down Monday after work. Tuesday morning,
can you describe that meeting without, you know, I know attorney-client communications is off limits, but how would you describe that meeting to someone? Like, was it different than meeting other clients for the first time?
Who might ask that question?
The first meeting?
Yeah.
No, it was a 4-hour meeting. I usually don't meet with clients in the jail for that long, so I gave her a chance to talk and just listened. For a long time, she had a lot to say. Obviously, she's been in jail for 4 years.
She always does.
And, you know, we had a good meeting. Just, again, I think she has trust issues because she felt like she did have some good lawyers that were on her case and just withdrew because they would get in some arguments about issues, I guess. And so she said they wouldn't even tell her anything at the jail, but the next thing you know, she would, you know, be sent to court, and the lawyer had filed a motion to withdraw. So she didn't, you know, trust the lawyers because she didn't know who to trust. She'd been with so many. So a lot of it was just trying to build trust with her. After she talked a little bit, I told her a little bit about myself. So really feeling each other out and trying to build some kind of rapport was the first meeting, which was about 4 hours. But I think early on in the case, I was able to persuade her that I knew what I was talking about because I was prepared. When I got there, I was prepared, and I played part of that 4 hours. I played the prosecutor, and I pulled out the jury instructions, and I made an argument as a prosecutor would make to a jury, and I had her sit there and listen to it. And I think that was effective. I don't think she had anybody ever do that to her and explain it to her that way of how it would, you know, play out in court. And that got her attention. And, you know, initially I was going down there. Now, let me tell you, my initial thought going down there was this. She didn't have a lawyer. And once that happens, once they're pro se, then you know as well as I do that all these cases are up for negotiation. Plea agreements are pretty much on the table at any time, and judges recommend, the courts recommend, you know, you try to work cases out. The vast majority of cases get worked out with pleas. So, you know, I talked to her about that, and that was my intent. I'd called the prosecutor and told him I was coming down there to speak with her ahead of time, and he wanted me to file some kind of a notice of appearance, and I didn't want to do that. I wasn't ready to take on the case. So I got her to sign a document essentially saying, hey, I don't want to negotiate directly with you, state attorney. I would like for James Owens to work, just to talk to you. And so she signed that, and I did, for a couple of days, talk to the prosecutor. I was trying to resolve it.
Right. And
I felt like the judge is fixing to have a 3-week trial with a pro se defendant. Prosecutor is fixing to have a 3-week trial with a pro se defendant. It was not going to be fair. And I felt like they might be in a posture to try to negotiate something that would be doable. So that was my first intent, was not to handle the case, not to try the case. If we got something worked out, then I would file a notice of appearance, and we'd set it for a court date to resolve it.
That didn't happen,
was my first. No, it didn't. And, you know, I left that 4-hour meeting. I went to Tampa the next day, had court, and then turns out the investigator that had been assigned to the pro se litigant, Sarah Boone, he was meeting with her that evening at 7, so I asked if I could just join. So I came back over and spent about an hour and a half with her and Billy Lane, the investigator. And we talked some more, and I was convinced that there was going to be no plea bargaining. So I told her I was not representing her and I was leaving, and I emailed the prosecutor or called the prosecutor and said, look, we've reached an impasse. There's no agreement, and I'm not going to be representing her. And I went home.
That's very interesting. And this kind of goes back to what we've talked about in the past with Sarah, as far as she has this idea in her mind about how her defense is supposed to go. But there's a reality there that I think maybe the way James Owens has kind of laid it out for her, maybe light started to dawn on a marble head, something to that effect. But it's interesting that Sarah, as hard up for an attorney as she is, still wants to be in control, still wants to be in charge. And that just, I mean, you're looking at a substantial prison sentence. Why? Sarah just has a need to be in control. Common with the type of personality disorder. We talked about her cluster B personalities. She has to be in control. So let's see what happens when she finally starts seeming to, at least, well, we thought she's seen the light a few times, but apparently not. So let's see how this whole thing resolves.
And I want to say a couple of days later, Sarah called me and we talked some more. And I told her Vinny,
So, but at this point, she's now reaching out to you because she wants James Owens to represent her.
Well, we did connect. And I think she was overwhelmed being her own lawyer. She was stressed out.
Yeah.
She had all this discovery that she was trying to go over. She didn't know what she was doing. She didn't know the rules of procedure, rules of evidence. And she had told the judge, I think they'd had a couple of hearings on some issues, and she said, Judge, this is not fair. I don't know what I'm doing. And the judge kept saying, well, I'm sorry, ma'am, but this is your position. So I think she was just thankful that I came down to see her. We had, some good meetings. So I think she really needed some help. So I think that was partly to do with it, but there were still some issues because I think she was let down because I said I wasn't going to represent her.
Right.
So we got off the phone. I still said I wasn't committed to it, but I was thinking about it. But as you know, second-degree murder trial, and the judge had set a firm date for October the 7th, which is really difficult to do. I mean, you pretty much have to shut down your practice for 30 days or 6 weeks.
Absolutely.
And just to try to catch up and just be, which is essentially what I'm having to do. Now,
well, you've seen the body cam, all the interrogation videos, the 911 call, and then, of course, the cell video. It starts there, right? But in terms of getting prepared in 30 days for this trial, that's 4 years old and a lot of things have happened. Can you do it? And will you be ready?
Well, I'm gonna do my best with the time I've got left. That's all I can do. I'm gonna get some help. I've got to get some staff helping me. I've got a couple of lawyers that are buddies of mine that have offered their help. So
I should send that lawyer from the Northeast down to help you. Joseph Krowski is the guy.
Yeah.
We'll let him know that he's the reason that you jumped in the case. He may fly down there to help you. He's up in Boston. It's cold. He may come down and help you.
Yeah, that'd be great. And I've got two lawyers that, like I say, I think are going to help me, are pretty much committed to it. They're friends of mine, and I trust them, and they want to help me. And they realize I thought the case was going to be continued. I respect the judge's decision, but I really, really thought.
Let me ask you this. Have you spoken to any of the other 8?
Yes. I spoke to Ms. Cashman, who was the last lawyer that had it. I've tried to speak to Mr. Padilla out of Miami. He's the one that had the case initially. He had it for about 2 years, maybe 2.5 years. He did most of the discovery, took most of the depositions. I think they were pretty much ready for trial or getting close, and he withdrew. But I've tried to call him a couple of times. I know he's been in a double homicide case he just got out of, but I never was able to speak with him.
And you're doing this pro bono? I don't think she has much cash.
No.
What are you getting?
Well, Sarah's got to pay me back one day.
Okay. Okay.
Sarah's going to pay me back one day. Okay. So, remember, I just got done saying, or a little while ago, I said, it's not what the lawyer said, it's what he didn't say. So, you have a client who's been locked up in jail for the last 4 years. Okay. She obviously has very little money, if she has any at all. How is she going to pay for the legal counsel that she's getting? Because I would pretty much bet that the type of service that Mr. Owens provides comes at a premium. I mean, let's face it, you get what you pay for, right? So I'm curious what that meant, and the only thing that really comes to mind, and I think I touched on this in the video where she first threw out her little HR sign. I was trying to kind of walk you through who I thought might take on this case. So I thought maybe a young, eager go-getter, but then maybe not. Maybe they wouldn't have the experience. Somebody looking to make a name for themselves, maybe after the 8th attorney, probably not. But then you have to wonder, if she can't pay, how is she going to do this? Well, most true crime junkies know that there are things called the Son of Sam laws. The Son of Sam laws prohibit criminals from profiting off of their notoriety. Every state in the union has one. But what a notorious individual can do is they can sell their life rights away. And what that means is basically they sell their life story to somebody else or sign over the rights to it. And then that individual can try and negotiate a book deal, a movie deal, TV miniseries, whatever it happens to be, and try to recoup some of that money, or a percentage of that money, with a very small percentage of that going back to the individual as far as like commissary. And it couldn't be much. He couldn't ink a $10 million book and television deal and then reclaim whatever his legal fees are and then put the rest in her account if she's found guilty. Now, if she's acquitted, of course, she wouldn't be able to be retried again. Double jeopardy would kick in. She could, once again, still sell her the rights to her story. And in that case, she could pay him off plus a percentage for negotiating, however that's set up. And I really think that's the only thing that makes sense to me. Like I said, that's a lot of speculation, but I don't see anything else that makes a lot of sense. So, I think we got like a minute and a half left with him. Let's see what he's.
That was the agreement I had. I wanted her to understand that she needs to be self-reliant and she needs to be responsible for fees. I've got a bunch of clients that are paying me, and some of them only pay $50 a month. And but it's important to me. It's important to them, that we have an arrangement to make payments, and that's what I told her.
Do you think?
I feel.
Do you think she needs to tell her story in the courtroom?
Well,
please don't let her tell her story in court. Please don't let her.
Sarah's a unique individual. I don't know. In a criminal case, is the time to tell her whole story. I think if it's necessary, she'll take the stand. We're just going to see how the case plays out. We'll make that decision when the time comes. Of course, she's got a lot to say. She's filed a lot of pleadings, a lot of letters.
We've seen them. Trust me, we see. Yeah. So James, this is what I want to do. I want to stay in contact with you, and we are legitimately going to reach out to Joseph Krowski to see if he is willing to get down there if he needs an extra hand. But also wanted to let you know that I wanted to let you go now because I know you've got some discovery. You got a couple more hours tonight. You can jump in there and as you get ready for this. But I hope that we can reach out to you as we get closer and closer to the trial and grab a couple minutes of your time.
Thanks, Vinny. Appreciate you.
James Owens, folks, this is how the system works. It doesn't work if lawyers just look away and don't jump in like this. Everyone, whether you believe they're guilty or not guilty, it doesn't matter. Without defense attorneys stepping in like James Owens is in this case, the whole system crumbles.
Yeah, so we've got, so that's kind of interesting. And I really like how, the anchor kind of finished that off. I think that's a very important thing to say. Yeah, regardless of whether you think they're guilty or innocent, without due process, it really doesn't matter. I apologize for laughing during that video, but I think the very idea of Sarah Boone getting on a stand in open court and telling her story, it just is I would imagine that's one of those things that he's trying to negotiate and trying to explain to her why it's not in her best interest. So, y'all, that's the latest on Sarah Boone. Like I said, videos are going to be a little sporadic. I'm still trying to work out my time management and everything. Matter of fact, I'm going to have to start hitting the books here really quick. But Sunday, September 22nd at 6:30, I'm going to be going live with Katie Zed. And we're going to be talking about the Karen Reed trial. She's going to give us a little background on it. And I'm going to go over a few things. I'm going to go over a few things about the trial that have kind of struck me as far as police procedure and how some of the forensics just aren't adding up. And there's a lot of things that aren't adding up. But I am going to take questions. I'm going to try to limit those to like police procedure questions, because I don't want to go outside my lane, and I don't want to speak out of turn on something. And I'm very comfortable telling you I don't know or I can't answer that, because I think it's a lot easier to maintain your credibility if you just accept that you don't know everything instead of just trying to come up with some answer on the fly, and then everybody's like, hey, remember when you said this and you made a complete fool of yourself? All right. So that's going to be happening September 22nd, 6:30 p.m. Be with my partner in crime, Katie Zed. She's a wonderful co-host. If you haven't had the chance to see her channel, go over there, take a look. She's got a lot of great videos. She just did a video about cocaine hippos that drug kingpin Pablo Escobar had down in Colombia. And after they crippled the Medellin cartel, nobody knew what to do with these hippos. And they're kind of ill-tempered, and they're kind of creating a nuisance down there. But they've kind of become sort of a landmark. But it's left the country trying to figure out what in the world are we going to do with these things. I'd also like to say thank you to some new subscribers. I started teaching a criminology course at a college here in Texas, and some of my students wanted to show support, and they got on here and they subscribed. So y'all, thank you so much for that. Some of my classmates from law school found out that I host Cowboy Criminology and that I'm also a professor of criminology, and so they wanted to show their support. So to all of you, thank you very much. Y'all, I cannot overstate or understate. I'm not really sure which one of those applies. I cannot overemphasize how important it is for y'all to show up on September 22nd. I'm going to be making a huge, huge announcement. It's something very cool, something I'm very proud of, and something I'm very excited about. So, but you really want to be there, because it's gonna be something cool. So y'all, I'm Derek Judd, the Cowboy Criminologist for Cowboy Criminology. It's time for me to hit the books. Y'all take care. Have a great